for his 5 minutes of questioning.
Thank you, Madam Chair. Mr. Hurd, I read through your testimony in the appendix, actually made for some depressing reading in many ways. It looks like so many of the major infrastructure bills that we've passed that say we've streamlined permitting have not delivered on it. And actually, the larger the infrastructure bill, I think you pointed out, the less likely it is to address permitting reform that is needed to execute on these projects. One of the points that was raised earlier had to do with the page limits in the Fiscal Responsibility Act. One of our colleagues mentioned the 150-page limit for environmental impact statements and the 75-page limits for environmental assessments. Mr. Hurd, are appendices to these reports included in those page limits?
Absolutely. Absolutely not.
So agencies can just offload analysis into appendices?
Absolutely.
Okay, so the bloat remains.
Yeah, absolutely.
In your testimony, thank you for that. In your testimony, you also noted that in many NEPA cases, the goal of litigation isn't to improve environmental outcomes, but to exhaust capital and stall projects that are no longer viable. Where's the funding for this litigation coming from?
It's coming from a cast of characters. They fundraise off of NGO money, but they also fund it off of groups that are actively fighting against fossil fuels. And in many cases, it's not even the environmental NGOs; it's competitors that have a different energy source, and/or it's private property landowners. At the end of the day, it's a cast of individuals that have their own set of motivations.
Are you aware of any instances where government grants or proceeds from prior environmental settlements are used to finance those lawsuits?
I'm not aware.
Okay. You note that the Inflation Reduction Act gave $350 million for permitting support, but that the delays persist. In your view, is this proof that the bottleneck isn't just about funding, but about deeper structural reforms needed to NEPA itself?
Absolutely. If we have another bill with cosmetic fixes that doesn't actually fix permitting, but it says it in the permitting release, we're going to send the signal that we actually care about fixing the problem, and then it won't fix, and then we'll wait another 5 years, and the problem will get worse. The only difference now here is, for the first time ever, fighting and talking about NEPA as a rollback that's going to supercharge and erode NAGPRA rights, or 106 consultation with tribes, or it's going to, I like to use facts. There's no incident of that happening. NEPA's not getting torn down. Nothing's happening that the chairman or anyone else has proposed. And seeing ghosts and threat construction about making NEPA this big bad wolf when it's really just a statute to bring all these other statutes of that chart that I wrote a long time ago to a center, so that we can evaluate the impacts and the mitigation. If it's a bad project, turn it down. If it's a good project, move it forward. We, at the end of the day, what has happened here is that on the front end, to your point, and is that project sponsors on their own are spending that money to inoculate from an opposition and a theory that hasn't even been invented yet. Right? How do you write a project when you don't know what's going to be challenging you, because you can't even look at the statutes anymore, because the things that are actually setting projects aside, just like in Seven County, was not something that anyone could have ever envisioned.
Right. Mr. Mergen, I have a question for you. I read through your testimony and understand your point about the need to look at the FRA and how it's being implemented and wait and see. You mentioned having read Mr. Hurgott's testimony, and I don't want to put you on the spot, but I was curious about some of your feedback on a few of the points that he made about what the FRA required, and in his opinion, why that's not enough. Specifically, what do you think about this? And this is one that struck me as a reasonable point that he made, and I just wanted to get your response to this. Mr. Hurgott said lead agency designations and joint reviews, that process could be improved. He said lead agencies are responsible for setting and managing schedules, is what the FRA did. And his point was his criticism of it was that lead agencies were given responsibility without authority. They cannot compel cooperation, override disputes, or penalize delay. In practice, they're accountable for slippage, but powerless to prevent it. What's your reaction to that? Is that a good point, and in terms of that interagency relationship? And is that one area maybe where we could improve on the FRA?
Yeah, so I think that the lead agency aspect of this is an important one. I think it is important to have one agency take charge and manage the process. I think there are a lot of innovative ways to manage the process. We haven't really talked about dashboards today, but I think there is good evidence. I think Mr. Hurgott talks a little bit about that too, that dashboards can be very effective. The question that I think that you would have to think very hard about is, Whether the lead agency issue is better handled administratively, regulatory, by the people in the agencies themselves who deal with these issues day to day, rather than Congress trying to manage this process. I think that would be a mistake in the first instance. And I think, to go back to some of my prior testimony, what we have is a very confusing situation created by the Department of Interior with regard to guidelines versus regulations and different direction on public participation to different agencies. All of that, to go to your excellent point about lead agencies, is going to make that extraordinarily difficult. So I think this all starts in the agencies, and that the agencies can demonstrate the leadership to make the lead, the designated lead agency process work.
Thank you very much, Mr. Berger. My time has expired, Madam Chair. I yield back.
Gentleman yields back. Mr. Stauber, do you have?
Thank you, Mr. Chair. I'd like to ask unanimous consent to enter three articles into the record. The first one was by the Breakthrough Institute titled Understanding NEPA Litigation